Welcome to Global Online. In today's session, we will solve legal reasoning passage and MCQs from previous CLAT exams. We will focus on how to extract the legal principle, apply it correctly, eliminate wrong option, and select the most logical answer exactly as required in a CLAT exam. A new live CLAT batch is now available for students who want complete and guided preparation. This batch includes live interactive classes, updated legal reasoning techniques, topic-wise notes and worksheets, full-length mock test, regular performance tracking, and doubt-clearing support. So let's begin and sharpen your approach to legal reasoning for your CLAT exam. Let's read this passage. The Supreme Court on September 1 held that a child born of a void or voidable marriage can inherit the parents' share in a joint Hindu family property. A three-judge bench headed by Chief Justice of India D.Y. Chandrachud, however, clarified that such a child would not be entitled to right in or to the property of any other person in the family. A voidable marriage is one that is made invalid by the husband or a wife through a decree. A void marriage is invalid at its very inception. Chief Justice Chandrachud said the first step to the inheritance of a child from a void or voidable marriage would be ascertain the exact share of his parent in the ancestral property. This could be done by means of conducting a notional partition of the ancestral property and calculating how much of the property the parent would have got immediately before his death. Once the share of the deceased parent in the property is ascertained through such a notional partition, his heirs, including his children, by means of void or voidable marriage, would be entitled to their portion in the share. The Chief Justice said that Section 16 of a Hindu Marriage Act has statutorily conferred legitimacy to children born out of void or voidable marriages. In fact, Chief Justice Chandrachud pointed out that Section 16(3) stipulates that children from void and voidable marriages would have a right to their parents' property. The court said the intent of granting legitimacy to such children in the Hindu Marriage Act should also be reflected in the Hindu Succession Act, which governs inheritance. Children from void or voidable marriages come with the ambit of legitimate kinship and cannot be regarded as illegitimate by the Hindu Succession Act when it comes to inheritance. The case before the three-judge bench was focused on the amended provision in the Hindu Marriage Act, Section 13. Section 16(3), the case was referred to a larger bench in 2011 after a division bench of the apex court refused to follow past precedents and championed the cause of children born out of illegitimate marriages. So this passage explains the Supreme Court ruling that children born from void or voidable marriages are entitled to inherit their parents' share in a joint Hindu family property. The court clarified that while such children are legitimate heirs under Section 16 of the Hindu Marriage Act, their rights are limited to the deceased parent's share and do not extend to other family members' property. The ruling aligns with the changing social norms, recognizing these children as legitimate heirs under the Hindu Succession Act, reflecting a move away from past discriminatory practices regarding legitimacy in inheritance law. So we have a question here. Ashima and Ashok got married to each other in traditional Hindu ceremony in Kolkata, after which they both moved to USA, where Ashok had a job. In the USA, they had a child whom they named Gongol. Many years later, Ashima found that Ashok was already married to Sushma before their wedding in Kolkata. Ashok and Sushma also had a child from their marriage, Arpita, who was older than Gongol by 4 years. Ashok explained to Ashima that although he had no intention of cheating on her, he had to keep his marriage to Sushma a secret since his parents would have never agreed, as Sushma belonged to a different caste. Ashima is shocked to learn that her marriage to Ashok is void as per Hindu marriage law since Ashok was already married before their wedding. She is trying to explore possibilities so that Gongol doesn't lose his inheritance from his father's side of the family. Based on the reading of passage, what do you think is the correct position with respect to Gongol's inheritance right? So the question asks what Gongol's inheritance right given his mother's marriage was void because Ashok was already married. So the passage states children from void marriages are entitled to their deceased parents' share of ancestral property. So option A, Gongol could claim the entirety of Ashok's share of the ancestral property. This one is incorrect. Gongol gets a portion of Ashok's share only, not the entire share alone. In case of option B, Gongol would inherit the entire ancestral property as the only son of Ashok. So this one is wrong. The property belongs to the entire family and Gongol inherits only the parents' portion. In case of option C, Gongol would inherit his share from within Ashok's share of the full ancestral property without prejudice to the inheritance of other legal heir, including Arpita. So, in case of this option, this matches the passage's precise position. In case of option D, only Sushma and Arpita are the rightful legal heirs of Ashok. So this one is incorrect. The ruling confirms Gongol also has a right despite void marriage. So as per the passage, option C is only correct option here. Let's move to the next question. In the above fact scenario, consider a property that was purchased by Ashok from his own earnings in the USA, thereby not making it part of an ancestral property, but instead falling in the category of self-acquired property upon Ashok's death, who would have inheritance right over the said property. So this question is about who inherits Ashok's self-acquired property after his death. The passage notes that children from void or voidable marriages have inheritance right over the parents' self-acquired as well as ancestral property. Hence, in case of option A, Sushma and Ashima, both mothers are heirs, but children also inherit. Hence, option A is wrong. In case of option B, Sushma, Ashima, Arpita, and Gongol, as they are all his rightful legal heirs. So, in this case, Ashima is not a legal heir here. Mother's rights aren't emphasized in inheritance. Option C, Sushma, Arpita, and Gongol. This one is correct. Children and legal first wife inherit self-acquired property. Option D says Sushma and Arpita. So this option excludes Gongol unfairly. Hence, only option C, Sushma, Arpita, and Gongol is the correct answer here. Because Sushma is his first legal wife and Arpita and Gongol are the children of Ashok. Next question is based on your reading of the passage. How did the Hindu Marriage Act influence the outcome of the case on inheritance? Select one option from below. So this question asks how the amended Hindu Marriage Act, specifically section 16.3, affected inheritance right in this case. The passage mentions section 16.3 statutorily grant legitimacy to children of void or voidable marriages and mandates inheritance right under the Hindu Succession Act. So the option A, the amended provisions of Hindu Marriage Act grant legitimacy to children from the voidable marriages, and Therefore, this logic should be extended to children born of voidable and void marriages under the Hindu Succession Act. This one is incorrect as it includes void marriages as well. In case of option B, the amended provision of Hindu Marriage Act gives legitimacy to the second marriage, and therefore this should also have an impact on a Hindu Succession Act. So marriage itself not legitimized, but children are given legitimacy for inheritance. Option C, the amended provisions of a Hindu Marriage Act grant legitimate status to children from void or voidable marriages, and therefore this should also extend to the Hindu Succession Act. So this one is correct because it matches with passage. In case of option D, the Hindu Marriage Act has no bearing on the case in a question. So this one is wrong as it is the basis of the ruling. Hence, option C, the amended provisions of Hindu Marriage Act grant legitimate status to children from void or voidable marriages, and therefore this should also extend to the Hindu Succession Act. Next question is, 12-year-old Kausalya was married off to 23-year-old Dasharath in her maternal home in Uttar Pradesh. She completed her education after her marriage and went on to get a job as a teacher at a government school. Dashrath's family, however, was opposed to her taking up a job outside the house and insisted that she should stay at home and look after her two sons, Ram and Lakshman. Kausalya, however, was excited about starting her new job and sought advice from her younger sister, Varshini, who was training to be a lawyer. Varshini advised her that since she was married before she turned 18, her marriage was voidable and she could get it annulled, Kausalya, who was not very happy in her marriage, considers this option but is worried that her sons may lose their inheritance. Select the option that denotes correctly the status of Ram and Lakshman to inherit their father's ancestral property. So the question is whether children born of a voidable marriage retain inheritance right if the marriage is annulled. So passage state children from voidable marriages are legitimate heirs with inheritance right. Hence, in case of option A, Kausalya's children cannot inherit Dashrath's ancestral property but can inherit his self-acquired property. So this one is incorrect. Children are legitimate heirs for the both property types. In case of option B, both Ram and Lakshman can inherit their father's share of the ancestral property irrespective of the voidable status of their parents' marriage. So this one is correct. This matches the ruling. In case of option C, if Kausalya decide to annul her voidable marriage, she and her son would lose all rights of inheriting ancestral property from Dashrath. So this one is incorrect. Annulment of voidable marriage doesn't affect children's inheritance right. Option D, Ram and Lakshman can only inherit ancestral property from their mother's side since she decided to annul the voidable marriage. So this one is wrong. Inheritance is through father's ancestral property as well. Hence, only option B will be the correct answer in this case. Ajay is married to two women, Diya and Riya, and both don't know of each other. He was married to Diya first when they were both around 23 years of age and studying together in college. They have no children. He later got married to Riya in a temple and she had no idea about his first marriage with Diya. Ajay and Riya have two children, Raj and Rani. One day, Riya found out about Diya from one of Ajay's college friend. She wants to divorce Ajay but finds out that her marriage to him is a void since he was already married at that time. At a loss, she goes to a lawyer to find out about the rights of her children to inherit property, which is the most legally sound advice that the lawyer could give to her. So the question is, what advice should be given about inheritance right of children from a void marriage? The passage confirms children born of a void marriages are entitled to inherit. In case of option A, he would say that her children can still inherit property from Ajay thanks to the Supreme Court judgment. This was correct and aligns with the passage. In case of option B, he would advise her to get marriage registered so that they can inherit property. So registration doesn't affect inheritance right of children born already. In case of option C, he would advise her to ignore her marriage with Ajay since it is anyway a void marriage. This one is irrelevant because children's inheritance right stands regardless. In case of option D, he would advise her to speak to Diya and sort it out with her so that her children can inherit property since she would have the final say. So this one is wrong. Inheritance is a legal matter, not about the mother's consent. Hence only option A, he would say that her children can still inherit property from Ajay thanks to the Supreme Court judgment. This one is the correct answer here. Next question is, in above scenario, Riya wants to know if there is any way in which the judgment can come to her aid while inheriting property owned by Ajay. What would the correct position of a law? So does Riya herself as a spouse have a right to inherit from Ajay's given void marriage? The passage focuses on children's inheritance, not the spouses. Void marriages don't confer spousal rights. In case of option A, no, she cannot inherit property as the judgment merely talks about rights of children from void marriages. This one is correct. Passage indicates children's right, but spouses from void marriages has no such a claim. Hence option A will be the correct answer here. While in case of option B, yes, she should fight for her right to inherit property. This is not clearly supported. Spouse's right depend on validity of marriage. Option C says, yes, Ajay would have to give her property since he cheated on her, but the legal inheritance is not based on moral claims. Hence, this will be the wrong answer. In case of option D, she would get an equal share of property as Diya since they are both his wives who got married to him without knowing about each other. This one is wrong because void marriages does not make spouse equal legal heir. Hence, only option A is the correct answer in this case. Next question is, Smriti's first marriage was void due to being within the prohibited degree of relationship. Dhanalakshmi who is the daughter of Smriti from her first marriage, confronts her mother once she finds her identity, demanding her share in her mother's ancestral property. Smriti, however, subsequently married Drupad and has two daughters with him, Ira and Shira, and is not interested in giving any property to Dhanlakshmi. Dhanlakshmi decides to assert her right in a court of law. How would Dhanlakshmi's share be determined? So, can Dhanlakshmi inherit Mother Smriti's ancestral property despite being born from a void marriage? This is the question here. So, passage says children from void marriages have inheritance right to notional partition. So, in case of option A, Dhanlakshmi would not have any right in her mother's share of the property, since the right of inheritance pertains only to a father's share of a property. So, this one is incorrect. Maternal and ancestral property inheritance is a valid. Option B says Dhanlakshmi could demand a notional partition and get a share from Smriti's portion of her ancestral property. This one is correct because it matches with the passage. Option C, being a child from void marriage, Dhanlakshmi has no right of inheritance. This one is wrong. Passage affirms right of such children. While in case of option D, it is Smriti's decision as to whom she gives right in her property. This one is wrong. Inheritance governed by law, not a personal discretion. Hence, only option B, Dhanlakshmi could demand a notional partition and get a share from Smriti's portion of her ancestral property is a correct answer here. So guys, that brings us to the end of today's legal reasoning PYQ session. These questions are essential for building speed, accuracy and exam ready confidence. Students who want strong self-study support can check out the Law CET and CLAT book by Global Online Publication, one resource for complete preparation. This book includes entire syllabus covered in a structured manner, chapter-wise concept explanation, practice question with the solution, previous year paper included, mock test for real exam experience, quick revision notes and exam strategies. So the purchase link is available in the description. Like, share and subscribe to Global Online for more CLAT preparation content. See you in the next lecture. Thank you.